Hi everybody, my name is Riznyk and I'm the lead attorney at San Diego Biz Law. And I am going to introduce you to the world of litigation today. For a lot of people, it's a very scary world. And a lot of our clients, they come to us and it's the first time they're either suing somebody or been sued. And a lot of people don't understand it. So my goal is to kind of simplify it for you and help you understand the three phases of litigation as I see them. And to feel a little bit more comfortable with what it entails, where the costs go, etc., etc., so that you don't feel it's just a black hole. Now, my first emphasis would be to tell you if you can at all resolve a case, do it. I'm not a big fan of litigating as a way of resolving things, but regrettably sometimes the plaintiff, the person who starts the lawsuit, initiates the lawsuit, has no choice for political reasons or a statement has to be made about the way something is undergoing or the fact that the other party won't discuss anything with them. Leaves you but no option but to have to file a lawsuit. And there's nothing you can do about that. And as a high-level negotiator, I'm also aware that with some people, all the talking in the world isn't going to make a difference. They don't see resolution and teamwork as an option. So if they have to fight with clubs, which I consider litigation, then fight with clubs, and hopefully at some point you can get them to decide that they've spent enough money, or you've cornered them, and they will finally come to the table and resolve it. So that's the first thing you need to know. But the second thing is, what does happen if you're suing somebody or you're being sued? Well, in my opinion, there are three parts to litigation. The first part is the lawsuit. In creating a lawsuit, and I'm talking about something valued at over, a case where there's over $50,000 at stake here. In creating a lawsuit, you're looking at gathering the facts, researching anything that you need to research to make sure that your facts are congruent with the current law and the current cases and precedents, and then drafting the lawsuit. Usually you're looking at spending, anywhere from $5,000 to $15,000, depending on how much time it takes to create. But it gives you a ballpark idea. Again, the more sophisticated ones would take 15. A lot of the easier ones can be created for 5, some for even less. But by the time you have all the meetings with the clients, plow through a bunch of documents that they bring you, conduct your research, write the lawsuit, it's easy to have spent 10 or 15 hours, which really, if you think about it, is the equivalent. 15 hours is almost like 2 work days. It's not that much time when you're busy every second of it doing something. That's the most crucial part, because once you file that lawsuit, you're bound by the allegations that you made, and now you've started an action that you can't just withdraw from, because if you just choose to withdraw, the other side may file a lawsuit for what's called malicious prosecution, and you're going to have to pay their attorney's fees. So think about this one very carefully, because once you put that train in motion, it's in motion. And now to get out of it, the first thing you're going to have to do is negotiate with the other party that each party pays its own costs, because otherwise a lot of people have been tricked into stopping the lawsuit, and then they ended up with an action for costs. So you have to be careful with that. And once the lawsuit's been filed, the second part, and there's really a 2A and a 2B in my opinion, is discovery and motions. Now, discovery. Discovery is where you get evidence from the other side in order to make your case. And you could ask questions. Those are called interrogatories. And there are 2 types in California. There are form interrogatories, where you just check off the form as to what information you require, send it out to them, and they and their lawyers will be very busy creating accurate responses to these. And that's an easy way to drive up their legal bill, of course, and that's what many of them will do to you if you're being sued. It's strategic. In some cases they need all those answers, in some cases they don't, but they're thinking to themselves, you know what, let me put them or her in a corner by asking more and more questions, to which they have to waste legal fees on having them answered, even if I don't want to know what the answer is. The other thing is request for production of documents or other things. Be careful when you send out a request for production of documents. I've seen a case where they brought an actual, I forget how many ton truck with the documents that were requested. That's how many documents there were. And you can, of course, imagine what that's going to cost in legal fees for a lawyer, even a paralegal, to plow through all those documents, read them, scan them, organize them, and understand them. So be very narrow in the scope of your request for production. You can also send out special interrogatories where you make up the question. Relevance is the key. It's got to be relevant to the case. And you can ask questions of the other side. You can also file what's called RFAs, requests for admission. You can ask them to admit or deny certain facts. And of course, you want to be very careful strategically so that whatever you're sending out, or if you're the one who's responding, the answers have to match. What's in the documents must match the RFA, must match the interrogatory. Now, if you want to really spend some money on litigation, depositions are very expensive. They can cost you, $1,000 to $2,000 a day, depending on whether you're having it simply written up, transcribed, or videotaped as well. But especially if you're having them videotaped, you have the opportunity of observing the other person when they answer the question. So they have very strategic value to them. But of course, if your lawyer is there who's asking the questions, that lawyer, if they're experienced enough, will understand from the way the question is answered what the deponent is really thinking. But of course, there's more than one use to a videotape deposition. I don't want to get into technical details with you. But again, that's an expensive way of doing it, and you can depose not only the party who's on the other side of the case, but if there's somebody else, potential witness, somebody who has potential information that's valuable to the lawsuit, you can also depose them. But be careful, because there are some people in lawsuits, they want to depose everybody that potentially has anything to do with it to get their information, but also at the same time to harass the other party. So you see how I'm showing you the balances? There are two sides to everything that takes place in litigation. And one can be a strategic game to wear the other person down, to take away as many hours from their work as possible, to drain their wallet. And another is to actually get accurate information and move on with the case. Now, at the same time that discovery is taking place, and there are discovery cutoff dates, you can file a motion, or the other side can file a motion. They can file a demur. I mean, there's really no end to the motions. A motion is basically where you request the court for something. You're basically saying, for example, their lawsuit doesn't state a cause of action. You can state that they're not responding in time and you want something settled and closed. You may make a motion for a request for an extension of time in which to respond to something because you have to get the available information. So a motion is basically a request. The problem with a motion is there are costs involved in researching it and writing it. So it's not like a big lawsuit, but it's a mini suit within the bigger lawsuit. And of course, and then you've got to drive to court and you've got to represent the side. And there's also something called an ex parte motion that can be heard very rapidly with very little time to prepare, especially when there's something that's imminent and urgent. So again, I'm trying not to be technical just so you understand it. Now these two things, as you can see, can easily drive up your costs. I mean, to prepare a motion can run you anywhere from $500 to $3,500. Court time, what are you looking at? Anywhere from, you're usually only heard for 5 to 10 minutes, but most lawyers charge you driving time there and back, which makes sense, of course, since they can't be at the office being productive. And then the waiting time, you can't arrive in court the exact same minute that your case is going to be heard. What if there are traffic jams, et cetera, et cetera. So a lot of time is spent. And again, some motions, I was involved in a case many years ago. This is not a joke. Where the opposing counsel, which is what you call the lawyer on the other side, he filed 1 to 2 motions every single week for months. Even the judge was yelling at him, and I won't get into it, but it's crazy. He had a motion for everything. It didn't matter what you do, you had to file a motion. And we were there arguing and wasting valuable time and money for no reason. So the personality of the lawyer you choose is going to be very important. He was more of a, let's go with the teeth rather than a strategic lawyer, because in the end, what started out as a multi-million-dollar lawsuit, I think settled for $10,000. And what was worse, he did it on a contingency, so he made like $4,000 for a year and a half of work. But at the end of the day, those are the first 2 major parts. And the third is trial and everything that's involved in trial. Are you going to have a judge trial? Are you going to have a jury trial? What are the strategies behind each? Would you like to have a mock trial? Put it in front of 12 potential jurors and see how they feel about your client, for one. What kind of a witness does your client make? Do you require other people to be witnesses? If you're dealing with a very sophisticated case, let's say medical malpractice case, a real estate case, any kind of case that has something that's very specific that the average person wouldn't know about, you may have to hire what's called an expert witness. An expert witness is somebody who works in the field and is very familiar with that area. Let's say that it's a kidney malpractice case. You hire a nephrologist who's an expert and knows these things. And there are some experts who do a lot of work in litigation, but they're very expensive. And the other side's going to want to have a deposition of your expert. Your lawyer's going to have to sit in on that. Or if you're on the other side, the exact opposite. And this person will also have to testify. So when trial comes along, there are a whole different set of things that have to be done. You have to prepare for that trial. It's good to spend a lot of time with your witnesses, especially your main client, and discussing what we're going to say, but not just what we're going to say, how we're going to say it. Because at the end of the day, although yes, we abide by laws, this and that, litigation is a game of strategy. It is very much a game, because most of the time you'll find out the person who does have the more experienced lawyer will prevail, because that lawyer knows the ropes. Because not everything is black and white, and there are so many shades of gray. I mean, if I'm picking a jury, depending on the type of case I'm doing, there's a specific type of jury that I want. But by the same token, let's say it's a criminal case and DA's picking a jury, well, they're going to pick a jury of what they're looking for, because that jury is more likely to agree with that one side. Or an expert witness may be favorable to one side and not to the other, and then the other side finds one favorable to them. But also you're going to have some expert witnesses who unfortunately should not be expert witnesses. They don't come across very well, so the jury isn't going to like them. They may be very brash, they may dress horribly, there are a number of factors. But I got involved in owning a film production company because one day, about 20 years ago, I took a course on acting for the courtroom. And I really got into the acting field and really enjoyed it, and then ended up making a number of films. So it is a drama. It is a theater in play. And the more psychology, the more you understand what's going on the other side, the more you can play the game. There are many words you could use here, but you understand what I'm trying to say. This is a very sophisticated game. And, whether the jury likes or hates the lawyer, likes or hates the defendant, why do people get dressed up in certain ways? Why do everything counts when you're in front of a jury? For example, if I got dressed up right now in a tank top and some shorts and flip-flops, would you give me that much credibility? But by the same time, I'm playing the game, right? But by the same token, it's still the same me. It's the same brain. It's just different a set of clothes. By the same token, this is no different. So there are two real parts of strategies. You've seen the three parts: the lawsuit, the trial, and then discovery and motions. But also the strategy, the overall strategy on how you prepare and attack. This is a war game. Make no mistake. You got to take it very seriously. So that strategy is very important, but then also the overall strategy of the case. It's really a strategy against the other side and a strategy of the overall case. And those two things will determine the outcome. Some cases we've been able to settle in 2 months. Some of them took 6 or 8. And again, it had to do with analyzing both of the sides, what was involved, what was at stake, what was settlable, what was negotiable, what was a non-negotiable. A lot of little things to know. But that's what you have. I read somewhere a few years back that the average cost of either prosecuting or defending a lawsuit is about $150,000 in San Diego. That's with all in, and if you go to trial, right to the finish. We're finding that a lot of cases settle at under 50. Even if we go to trial, we're usually not quite that high unless you've got a bunch of expert witnesses and depositions that change it to that. So not to make it scary. But there are many strategies that you can undertake to put an end to it. However, I will be creating another tape on negotiation as a solution. And that'll give you an idea of how to negotiate something before you actually get to this stage. Because trust me, this is a journey neither side will want to undertake. Especially now that there are budget issues and there are not enough judges and trials are taking a long time. Anyway, good luck in your business and stay out of court. Cheers.